Welcome to Negligence 101 Class 2. This video is going to cover how to analyze Element 1, duty, but we are going to do so under the modern model utilizing Restatement third of torts. Again, we are going to analyze Element 1, that's duty, and we're going to use the model that is the modern model, relying on the third restatement of torts. We ended lecture 1 with what I call as the Palsgraf dilemma. Both justices agree that negligence liability should be limited. The disagreement was which element should serve as the limiting principle, right? So both agree, yes, we need liability on negligence. We need to limit liability on negligence claims. So how do we do that? Well, we're going to do that with one of the elements. Great. Justice Cardozo said it should be the duty element. Justice Andrews said it should be the proximate cause element. Okay. Well, Justice Cardozo goes on to say, not only should the element that serves as the limiting principle for liability should be duty, that decision is a decision of law. And in such, that decision should be made by the judicial officer, should be made by the judge. Again, Andrew says, no, the element that should serve as the limiting principle should be the proximate cause element, and that determination should be made by a jury. Okay. Cardozo went on to say, well, let's talk about foreseeability. Foreseeability should be a factor when deciding whether or not to limit liability. Cardozo said the foreseeability should be as to the plaintiff. In other words, is the plaintiff a foreseeable plaintiff? Well, in order for the plaintiff to be a foreseeable plaintiff, the plaintiff would have to be located within what Cardozo describes as the orbit or the zone of danger. Andrews agrees that foreseeability should be a factor in determining whether or not negligence liability is going to be limited. However, the foreseeability is not to the plaintiff, and there is no such thing as a made-up zone of danger. The foreseeability, according to Justice Andrews, should be to the types of harm. So the question would not be, was this plaintiff foreseeable, as Palsgraf was eventually determined on? For Andrews, the foreseeability should be as to the type of harm suffered by the plaintiff. So ultimately, what are we saying? Cardozo is saying that the element of duty is particularized. There is a particular plaintiff. There is a specific identifiable plaintiff, and we identify them based upon the zone of danger and whether or not they're in it. Andrew says, no. As far as duty is concerned, duty should be generalized. There should be a general understanding, a general expectation that an actor is going to act with reasonable care. There is no particularized plaintiff. There is no made-up zone of duty. Get it? That's the dilemma. We agree that we should limit liability. We don't agree where that liability limit lives. With that being said, we 80 to 100 years later eventually get to the restatement third of torts. So 80 to 100 years later, what were we doing, right? We were doing something. Well, what we were doing in theory was Cardozo's idea of particular plaintiff, meaning foreseeable plaintiff within the zone of danger. But what we in practice continued to move toward was this ever growing importance of the factors that are considered when you're making proximate cause determinations, right? The factors that are considered when we make proximate cause determinations. Now, I don't want to go down the road of proximate cause, which the Restatement Third of Torts actually calls scope of liability, not scope of duty, but scope of liability. But I don't want to go down the proximate cause road yet, because we haven't gotten to that element yet. So we're staying focused on the duty element, but we had to introduce proximate cause because that's what Andrews relied upon. So what do we do in practice? What do we believe in theory? What did we do for the 80 to 100 years? That's what it was. We now are at the Restatement Third of Torts. What did the Restatement Third of Torts do? Which side? Was it Cardozo or was it Andrews? Which side did the Restatement Third of Torts rely on? Right. The Restatement Third of Torts took a little bit of both worlds. And you'll see what I mean when I say that, right? So the structure that's used to make the duty determination under the Restatement Third of Torts has 3 steps. Step number 1. This can be found in the Restatement Third of Torts, Section 7. Step number 1. Duty is presumed. What? Who is that? That's Andrews. Restatement Third of Torts, Section 7 instructs that duty is presumed. What does that mean? That means that in practice, we are no longer looking for the identified plaintiff, the particularized plaintiff, the specified plaintiff. We're no longer looking for the plaintiff, and we're no longer creating a zone or an orbit of duty. Under the third restatement model for establishing whether or not a duty exists, the answer from the start, according to Section 7, is the duty element is presumed. So what's the question that you're asking? Under Restatement Section 7, did the defendant create or increase the risk? Right? Did the defendant create or increase the risk? Pretty simple, yeah? If the answer to the Restatement Second of Torts is, let's go back here. If the answer is yes, the defendant conducted themselves in a way that increased the risk of harm to the plaintiff, not particularized, but to the world in general, right? To the plaintiff. If the answer is yes, your duty element has been answered. Then there's a duty. Really simple. You create the risk, you owe a duty. I'm done with my element 1 of duty. I'm not done with my liability evaluation, but I'm done with my element 1 evaluation. Remember, there's 4 elements. I've got a duty, I've got breach, I have causation, which looks at 2 independent types of causation, and then I have damages. Well, I'm just starting. So if the answer to Restatement Third of Torts, Section 7 is no, right? No, the defendant did not create or increase the risk of harm by their conduct or by their behavior. What do? We go to step 2. Step 2 takes us to Restatement Third of Torts 37. This is the nonfeasance section, right? If there's nonfeasance, there's no duty. What does that mean? If the defendant did not create the risk, just merely failed to act, then there's no duty of reasonable care owed to the plaintiff, right? Not really. Right. This really shouldn't be a period at the end of plaintiff. It's really more of a semicolon, right? Really shouldn't be a period. In fact, we're going to change it right now, and we're going to make it a semicolon, right? Why should it be a semicolon? Because if you did not create the risk by your behavior, by your actions, you just didn't do anything, you just simply didn't act, then it would make sense that there's no duty, right? It's 2 sides of one coin. On the head side or tail side, pick one. On one side of the coin, if you create the risk, you owe the duty. Flip the coin over. If you didn't create the risk, then you don't have a duty, right? Makes sense. One coin, 2 sides. But there's a semicolon there because if I didn't create the risk, I do not have a duty unless Restatement Third of Torts, sections 38 to 44 say that I do. Right? Don't you love the law? It is the best thing since sliced bread. Absolutely. Right. Start again. 3 steps. Step 1. Did the defendant create the risk? Yes. Stop. Duty analysis over. Now I get to go to my next element. Okay. Did the defendant create or increase the risk? No. Step 2. If the defendant did not create the risk and just merely failed to act, then there's no duty. Do I stop? No, because I've got a semicolon, not a period, unless Restatement Third of Torts, sections 38 to 44. The duty of reasonable care owed by the defendant to the plaintiff may be reinstated, right? 37, in effect, dismisses the duty requirement, right? Because if you didn't do anything to create or increase the risk, then what duty do you owe? You don't owe any. However, the duties reinstated under sections 38 to 44, right? And why would it be reinstated under 38 to 44? Because the law recognizes duty of reasonable care in certain circumstances. What are those circumstances? Circumstances of a special relationship, circumstances that of responsibility that a defendant might owe to the plaintiff or to a third party, circumstances wherein the defendant may have some level of control. Got it? 3 steps. Restatement 7, Restatement 37, and then Restatements 38 to 44. Remember, this is the modern negligence structure for duty. Restatement Third of Torts. Excellent. Well, what's this? What are these sections 38 to 44? Because class 101 video 1 explained and showed you the restatement 7 of torts, the restatement 37, and restatement 3 of torts, right? All of these are the third restatements. And we showed you, right? We kind of highlighted for you what those sections meant, but we did not go into detail on sections 38 to 44. So why don't we do that now? Remember, restatement 3 of torts. It has been adopted. It has been published. It is good law. Okay. Restatement 3 of torts. That is, let me be really clear. The restatement 3 of torts as it relates to negligence, because all of the sections of the 3rd restatement of torts have not been adopted, right? So got to make sure you're arguing good law. As to negligence, the restatement 3 of torts has been adopted and is what most jurisdictions are using. Here we go. Step 1, I look at 7 and I ask the question, did the defendant create or increase the risk of harm by their conduct or their actions or their behavior? The answer is yes, then they have a duty. If the answer is no, I go to restatement 3 of torts 37. 37 is, if the defendant did not increase or create the risk of harm by their actions or their behavior, right, or their conduct, then they don't have a duty unless restatement 3 of torts, section 38 to 44 say that they do. Here's 38. 38 is an affirmative duty based upon a statute. Again, 38 is an affirmative duty based upon a statute. What does that mean? That means that a duty of reasonable care exists because the legislature has decided it exists. Get it? I got a statute or a rule of law that says in this circumstance, the defendant would owe the plaintiff, who is general plaintiff, right, a duty of care. Be real careful right here. The second element is breach of duty, right? First element's duty, second element's breach of duty, third element's causation, and then we get fourth element damages. In the second element, which is breach of duty, there is a way to breach your duty. That's a way for you to fail to meet the standard of care. You can breach it by way of negligence per se. That's by way of violating a statute, right? That is not what we're talking about in duty. So a legislatively mandated duty, please don't conflate element 1 and 2. Please don't refer to a legislatively mandated duty as negligence per se, because it's not. Okay? Excellent. Here's the question that you're going to ask to determine whether or not 38 exists. Has a statute imposed an obligation to protect or assist? Has a statute imposed an obligation to protect or assist? If the statute imposes an obligation, then the court may recognize the defendant having an affirmative duty to act. If you're taking an exam, how will you know that you have that situation? There's going to be a statute or a rule of law in the hypothetical, that reads something like must, shall, required, or duty to, right? You're looking for those active, affirmative words that indicate that the defendant, by way of law, has a duty of care. Easy enough to spot. Let's go to 39. What is 39? 39 is duty based on prior conduct, creating a continuing risk. Duty based on prior conduct, creating a continuing risk. In other words, if you set the risk in motion, you don't walk away with clean hands. If your prior conduct, listen to what I'm saying, prior conduct created a continuing risk, you may have a duty to take reasonable steps to prevent or mitigate harm to others, right? You may have a duty. Well, is that malfeasance? It is not malfeasance. Well, hold on a second, right? Because malfeasance, which is Restatement, third of Torts 7, that is, if you do something, right, you have affirmative conduct or affirmative behavior or an affirmative act, right? You do something that creates the risk, then you have a duty. That's malfeasance. That's Restatement section 7. Yeah. Isn't 39 saying the same thing? The difference is in the timing. So when you're in an exam, please make sure that you're paying attention to the details. The difference between 39 and 7 is in 39, we have conduct that is not contemporaneous to the harm. Here's an example. A driver is traveling on a rural road at night. A deer suddenly runs into the roadway. The driver swerves to avoid the deer, right? And it's reasonable. Yeah. I don't care what you're driving. You don't want to take on a deer, right? And so the driver swerves and misses the deer. Phew. Nicely done. However, when the driver swerved reasonably to miss the deer, the driver hits and knocks over a large road construction warning sign. Still not a problem, right? What's the action? The action is I swerved. Yeah. Is there any harm from the swerving? No, there's no harm. So I don't have a section 7 happening here. Okay. In my swerving, I knock over a huge construction sign that tells drivers a warning, right? What's the harm? I mean, there might be some harm to my vehicle, but I'm not going to sue myself for negligence, right? So what is the action? Knocking over the construction sign. If your facts then indicate that the driver is aware, or if the driver should have been aware, that the warning sign, public facing, is now lying in the roadway, partially blocking the lane. And if they choose, the driver, not to stop or to call help to fix that situation. What situation? The situation of the big construction sign now in the middle of the roadway, and we were already told that it was dark and it's at night. Having created that hazard, even though no harm happened in the moment, if another car, let's say 30 minutes later, comes down that road and strikes the fallen warning sign or falls into a huge pothole because the warning sign is down, or is somehow in some way injured as a result, right? Suffers harm as a result of that sign having fallen and that sign being in the roadway. Guess what the driver previous who knocked the sign down did? Prior conduct that created a continuing risk. Do you see it? Take a second. The driver who knocks over the sign creates a hazardous condition, not an injury, creates a hazardous condition that later results in an injury. So pay attention to the timing. Let's go to, that was the example. Let's go to 40. What is 40? 40 is duty based on a special relationship with the plaintiff. Duty based on a special relationship with the plaintiff. So what am I saying? I'm saying that the defendant has a special relationship with the plaintiff. The connection is between the defendant and the plaintiff. That special relationship creates vulnerability or dependence, or it creates an ability to protect or assist, right? It creates a vulnerability or dependence. For instance, the plaintiff reasonably expects some level of protection from the defendant, right? Or what about this? The defendant occupies a protective or maybe even supervisory role over the plaintiff. Or consider this one. The defendant has control or access or institutional capacity. What are some of those relationships that are pretty well known and that are pretty popular enough that you might see them in an exam? Some examples might be common carrier and a passenger, or an innkeeper and a guest, or a business and a patron. This is not premise liability. We're looking at special relationships right now, right? We'll get to premise liability later. Schools, students, employers, employees, landlord, tenants on a limited context, right? Custodial settings, because we said an institutional role of protection. The key point to remember is don't focus so much on the label that you overlook the function. Okay, it's the relationship between the plaintiff and the defendant. Does it make sense? Is it reasonable for the plaintiff to expect protection or assistance from the defendant? Yeah? All right, that's 40. Let's go to 41. Duty to third parties based upon the relationship. Now, I know it's a little bit of whiplash, but I'm going to take you back to 40. Duty based on special relationship with the plaintiff. That's the defendant has a special relationship with a plaintiff, where 41 is duty to third parties based on a special relationship with the person who's posing the harm. Now the special relationship is not with the person harmed. The special relationship is with the person posing the harm. You get it? Stop for a minute and think about it. So the relationship is not between the defendant and the plaintiff, as it is in 40. The relationship is between the defendant and the dangerous person. What are you looking at? You're looking at the defendant having some level of control over the third person or some duty to warn the victim, right? A Section 41 duty of reasonable care to protect others may arise. Take your time. Think about it. I'm sure all of these ideas are coming to your head. The defendant knows or should know the dangerous person poses a foreseeable risk of harm. Yeah. Well, I know that this person has the potential to be dangerous to other people. Does that trigger my 41 duty? Not by itself. Not by itself. The risk must be identified. The risk must be directed to an identifiable person, right? This isn't just some generally, I'm irritated kind of danger. This is a specific risk, specific person, right? Does that give me the duty? It does, if the defendant has a practical ability to warn or protect, right? So these are not theoretical aspirations. These are practical expectations. So what has to happen in order for a defendant to have a duty to a third person, because the defendant has a special relationship with the person who's going to cause the harm? There has to be an identifiable victim. The harm that is threatened has to be a harm that could be reasonably foreseeable. And the defendant must have the practical ability to warn or protect the third, the victim, for all intents and purposes, right? Identifiable victim, foreseeability of the harm, practicality of the intervention. Here's your question. Does the defendant owe a duty to protect to others because of the defendant's relationship with a dangerous person? Okay. All right, let's move on to 42. 42 is you would have a duty of care if you decided to undertake the responsibility of care, right? Remember how we get to 38 to 44. We get to 38 to 44 by going through step 1. Did the defendant create or increase the risk of harm? If the answer is yes, the duty element analysis, just the duty element analysis stops. Got a duty. If the answer is no, that the defendant did not create or increase the risk of harm, I go to 37, which is the flip side of 7. 37 says, if you didn't create the risk, you don't have a duty. Unless, right? Unless, now we're on 42. Unless you undertake the duty of care. Well, what are you saying exactly? Exactly, I'm saying that Section 42 is for voluntary assumption of responsibility. Here's the theory. If you undertake to render services to another person, right, and those services are intended to reduce the risk of harm to the other person, then you must exercise reasonable care in performing that undertaking. Get it? The law is not punishing kindness, but it is enforcing competence, right? It's not saying, oh my goodness, how amazing you are that you undertook this, and now we're going to punish you because you weren't perfect. No. That's not what's being said. But what is being said is be very thoughtful about what you do before you do it, and be very intentional about what you're doing before you do it. If you choose to undertake the responsibility to care for another, then do that with reasonable care. Does that make sense? Right? For instance, if you've started CPR, you're walking down the street, you see somebody passed out, you're like, oh my goodness, I've got CPR training, right? What's the first thing you do? You identify somebody specific, you tell them, you go call 911, right? And then you start your breaths or chest compressions or whatever it is you've learned in CPR class. And let's take, for whatever reason, it takes ambulance response a little bit longer than you really had the endurance to continue. And so now you're getting a little tired, you're getting a little winded, and you're like, whew, the person hasn't come to yet, but I did my best, and it's taking the ambulance or the paramedics too long. You know, I tried, I'm out of here. Yeah. It doesn't happen that way. Once you undertake it, then you are responsible for exercising reasonable care. Okay. Then we're going to go to 43. What's 43? Now, 42 is if you undertake duty of care. 43 is duty to a third party because you undertook the duty of care, right? So what is 43? 43 is one more party added to 42. 42 is between the actor and the person that they're trying to assist, right? 43 is the actor and the party that the actor, the defendant, tried to assist, but harm on a third person. So what does that look like? If you undertake to render services to one person, you may, now all of these are written this way, all of these are written as, you may owe duties to others when that other reasonably relies on the care that you are providing, right? If a third party reasonably relies on you undertaking the care of the first person, then your performance may need to include yet the third person. If you undertake to render services to one person, you may owe duties to another person, provided that other person, that third party, reasonably relies, right? Or second scenario could be where you're undertaking to assist the first party has an impact on the safety of the third party. That pause was intentional for you to think about it. And then the third way that you taking to care for someone voluntarily that you don't otherwise have a duty of care to do right? And how by doing that, it may have a negative impact on a third party that you're now going to be responsible for is if your actions to care for the first party increases the risk through negligent performance or withdrawal to the third party. Got it? So the duty under 43 does not depend on the relationship between you and the third party. The duty under 43 to the third party arises from the scope and the consequences of the undertaking. The scope and the consequences of the undertaking. Here's an example. Let's look at private security. A shopping mall contracts with a private security company to provide overnight patrols of the parking lot. Or let's make it a little bit more specific, of the parking garage. The contract is between party A, the mall, and party B, the security company, right? Regular shoppers and employees, we're going to call them parties C, know that security patrols occur at the garage, and they rely on those patrols at the garage. Let's say one night, the security company, that's party B, negligently fails to patrol the parking garage, leaving it unmonitored. And let's say a patron, one of party C's, is assaulted. What do you think happens? Although the undertaking was rendered to the mall, that was parties A and B, the security services foreseeably affected the safety of the third parties using the garage. Why? Because the patrons reasonably relied on the presence of security, right? And the negligent performance of the security increased the risk of harm. Under 43, the security company may owe a duty of reasonable care to the injured party C. Remember, security undertakings almost always implicate third-party safety. Got it? Slow down. Read the facts. Get a clear understanding of who's doing what to whom and what impact that might be making to the whom or to the third party. So just slow down, right? Slow down. I know we are always making you feel like the walls are closing in on you. Don't get me wrong, they are. But you still have to be methodical and meticulous in your evaluation and your assessment. Let's get to the last one. Restatement third of Torts, section 44. Duty based on taking charge. Duty based on taking charge. Well, that sounds a lot like 42, an undertaking. Well, the difference is 44 is focused on control, right? 44 is focused on, there's no better word, control. If you take control of a helpless person, you can't just then decide, this wasn't what I thought it was going to be, I'm going to take off. If the defendant takes charge, I know that you're thinking this is the same thing as an undertaking. Give me a moment. And I'm going to give you some examples that are going to help you discern between 42 and 44. Okay. If the defendant takes charge of someone who is helpless or imperiled, the law imposes a duty to act reasonably while the person remains in your charge, right? Watch for facts like this. The defendant moved the plaintiff to a place of isolation so that no one else could access. The defendant took control of others such that no one else could intervene, right? So those are the kinds of facts that you're looking for that would trigger a situation under 44. Yeah? Awesome. These sections, Restatement Third of Torts, sections 38 to 44, identify situations where the defendant has a legally significant connection either to the plaintiff or the risk, either through law, prior conduct, relationship, undertaking, or control, right? Such that inaction is no longer treated as a 37 mere bystander behavior. Yeah, awesome. Here is a rule statement template that takes you from actually rule 7 to rule 44, right? This is just a random template. I'm not saying that you should go and give this rule statement to your professor and your professor is going to fall out your feet and tell you how amazingly brilliant you are. But I'm saying that this rule statement should be able to help what we've discussed over the last 45 minutes and should be able to put it in some context for you, right? So here it is. Under the Restatement Third of Torts, Section 7, a defendant whose affirmative conduct creates a risk of physical harm generally owes a duty of reasonable care, right? That's what we discussed. By contrast, we're flipping the coin. Under Section 37, there's ordinarily no duty to exercise reasonable care to protect others from harm, right? That the defendant did not create, comma, absent a recognized exception, such as those set forth in 38 to 44. I like this generalized rule statement, number one, because I created it. Number two, because it gets you from 7 to 44, right? Not a rule dump, because you're not listing in here 38, 39, 40, 41, 42, 43, 44, but complete in that you are laying out the protocol that you're going to follow. You're laying out the mechanism by which you're going to evaluate the facts in the analysis, right? To reach a conclusion about duty of care. Here's a wrap up. Modern duty analysis, please stop and understand. I'm not talking about Palsgraf duty analysis, where Cardozo ruled and said we're looking for a foreseeable plaintiff in a zone or orbit of danger. I'm not doing Palsgraf Cardozo rule. I'm not doing the alternative, the dissenting opinion, which is Andrew's rule of duty analysis. This is the modern duty analysis pursuant to Restatement Third of Torts. Did the defendant's affirmative conduct create a risk of harm? Yes. Duty analysis stops because you've determined that you've got duty. Because if you create the risk, you owe a duty. No, I got to go to step 2, which is 37, which is the flip side of 7. If the defendant's affirmative conduct did not create the risk, that's nonfeasance, which means I didn't create the risk. I don't have a duty. I'm merely a bystander. But I never stop there because I'm not done. Because I may be more than a bystander if one or more of the exceptions in 38 to 44 apply. Boom, 3-step modern day duty analysis pursuant restatement third of torts. Got it? I'm going to go through a couple of cases. In my class, we had maybe 9 or 10 cases that we literally did step 1, step 2, step 3. I'm not going to do that on this PowerPoint slide, but I'll do the first couple of cases. One of the cases that I assigned my students was the Yania v. Began case. Before I get to the case, I do want to just take a second, side by side, to address malfeasance and nonfeasance. Malfeasance requires an affirmative act. Nonfeasance requires no action. Get it? Mal, M-A-L, prefix means bad. Malfeasance requires an affirmative act. Nonfeasance is a failure to act. Let's look at malfeasance. Malfeasance, there's affirmative conduct by the defendant that creates, increases, or maintains a risk of physical harm, right? That is risk creating conduct. Get it? That lives in Restatement Third of Torts, Section 7. That's actually 7A, right? Do you need to understand 7B? Yes, you do. But the malfeasance, which is what I'm talking about right now, lives in 7A. If malfeasance is present, that's a yes to did the defendant create or increase the harm, then your duty is presumed because under the modern platform of duty analysis, we've got a general duty requirement. Got it? And if I answer the question in the affirmative, if I answer 7A in the affirmative, I don't need to go to 37, right? Because I've already established my duty. Let's move to the next element. Cool. Nonfeasance, again, is a failure to act. That's when the defendant did not create the duty. They're simply a bystander, right? That's inaction, right? That lives in Section 37. No duty because I didn't create the risk. But you've got to remember that's a semicolon with an unless, right? The analysis for duty does not end automatically with I didn't create the risk. I don't have a duty. All right. Okay. Fantastic. Let's jump into a couple of these cases. The Yania v. Began case. Yania v. Began, real simple case. Really, really simple case. If you have not been assigned this case, go look at this case. We've got 2 coal miners, not M-I-N-O-R, but M-I-N-E-R. 2 coal miners. And they're working on this drudge or working where this ditch is, and this ditch has water in it. Began starts to urge Yania, jump in. You should jump in. You should jump in. Don't be afraid. You should jump in. It takes a little bit of persuasion, but eventually Yania doesn't listen to his right mind and jumps in. Unfortunately, Yania drowns. Yania's wife brings a wrongful death based on negligence, right? Potentially 2 theories. One, you were negligent in that you did something, Well, there, right? You did something. You did something. There was some affirmative act. What was the alleged affirmative act? The taunting, right? The taunting. And if I'm not successful on that theory, my second theory is once Yania started to drown, Began did not assist. Okay, here's the theories. Court said the verbal taunting, the verbal urging doesn't rise to a level to meet the required standard for affirmative conduct. All right, so you're going to lose on that one, but that's okay. I alternatively pled, which means maybe I win on the nonfeasance if I can establish that 38 to 44 required you to act. Okay, here it is. Ready? Step one. Did the defendant create the risk? If the answer is yes, then we have a duty and we stop. If the answer is no, we proceed to 37. If we find that the defendant did not create or increase the risk, is this pure nonfeasance? What does that mean? Is this simply just a bystander watching who had no duty to do anything? Not legal. These are not moral questions. These are legal questions, right? No legal duty. Well, I don't know. Let me run through 38 to 44. Are you saying that I have to go through 38 and 39 and 40 and 41 and 42 and 43 and 44? Absolutely. Because how are you going to know whether you have one exception that's applicable or more than one exception that's applicable unless you go through them all? Yeah, let's apply. Did the defendant create the risk? The court said no. The court said that the verbal taunting did not equal an affirmative conduct. So the defendant did not create the risk. What do I do now? I go to 37. If the defendant did not create the risk, there's no duty, right? I don't know. I got to go through 38 to 44. All right, well, let's do that. Let's apply 38. 38, remember, gets us to an affirmative duty based on a statute. Given the facts of the case, there's no indication that the legislature intended to create a duty of care in that situation. So 38 doesn't apply. Great, let's go to 39. Duty based on prior conduct, creating a continuing risk. Yeah, we don't have any conduct that we don't have any indication that this defendant engaged in conduct that created the continuing risk, right? What was the risk? The risk was the risk of drowning, and there's nothing to indicate that the defendant had done anything to create that dredge being full of water. So 39 didn't apply. Great. All right, well, let's go next to 40. Duty based on a special relationship. Is there anything that's indicated in the facts that would establish that Yania was dependent on Began? Was there anything that indicated that the plaintiff was vulnerable to the defendant? Was there anything to indicate that the defendant actually exercised control over the plaintiff? Was this a common carrier situation or an innkeeper hotel situation, business invitee situation, school student situation? No, none of that. All right, none of that. So 40 doesn't apply. Okay, well, Let's keep moving. Let's go to 41. Duty to a third party. Well, we don't have a third party injury right here, right? We've got the plaintiff and the defendant. We don't have another party, so we don't need to spend a lot of time on 41. Let's go to 42. Duty based on an undertaking. No, defendant didn't undertake to try to assist the plaintiff. So 42 doesn't apply. Let's go to 43. 43 again is third party. We don't have a third party here. 44 and 44 is duty based on taking charge. Are there any facts to indicate that the defendant took charge of the plaintiff? Anything that might indicate that the defendant isolated the plaintiff from help, any right to control of the plaintiff, right? None of that is in 44. So I don't have 38, 39, 40, 41, 42, 43, or 44. So that means I have no duty. Negligence claim fails because my rule of law for negligence is conjunctive. If I cannot make one of the four elements, the negligence claim for liability is over. Yeah? Got it? Okay. I like tables. There's a table for Yana v. Biggin. Gonna do Washington v. Louisiana Power and Light. I'm gonna do Washington v. Louisiana Power and Light because as I assigned this case to my students affirmed how quickly we can get distracted, right? And so let's just go through the case really quickly. Washington versus Louisiana Power and Light. What do we have? We have Louisiana Power and Light having laid some electrical lines, and as the power and light company are responsible for maintaining the electrical lines. We have Washington, who's got his radio with his antenna. Unfortunately, it makes connection to a power line that has not been insulated, which means that line is hot, which means Washington was executed. Okay. Great case when it comes to practicing your power of discernment, because here we go. First question, did the defendant create the risk? Well, what's the risk? The risk is leaving open that live wire, leaving that electrical line uninsulated. That's the risk of harm is somebody's going to come in contact with that non-insulated power line. And that's what happened. So did the defendant create the risk? Yes. I'm done with my duty analysis. I'm done. It's over, right? Right. If you read the case, which I hope you read all the cases that you're assigned, the court ultimately determines no liability on the power company. Okay, not a problem, right? Well, if you're not paying attention, you forget that when we are looking at the duty element, that's just 1/4 of the evaluation, right? Of the negligence liability evaluation. So even though there was a duty by the Louisiana Power and Light Company, the court ultimately decided that one of the other elements wasn't established. And if one of the other elements isn't established, what do you have? You have the death of the liability claim. So let's apply. Did the defendant create the risk? They did. Those are their power lines that they put up, that they didn't insulate, And the power company is in the best position to know what happens if this live power line, if somebody comes into contact, even if they are also negligent. Let's not jump to contributory negligence. We will get there. That is not this video. This video element of duty. Great. With that being said, did the defendant create the risk? Yes, they did. My analysis stops because I've established my duty element. Don't need to go any further. Got it? Great. Here's the last case that I'm going to go over. This is the Rowland versus Christian case. This case isn't one that we are going to apply the modern duty analysis of Restatement Third of Torts, Section 7, 37, 38 to 44. This case I want to offer because this is the case where California makes the decision that they are adopting the modern platform for analysis, that's 737, 38 through 44, when it comes to premise liability. And they are rejecting the previously adopted categories, right? Categories. We're going to get to premise liability again. Don't want to get there yet. But when we get to premise liability, you're going to have what I call Rowland states. That's California, Hawaii, Colorado, Alaska, other states that have adopted. We have a way to determine whether or not there is a general duty of care. And that's step 1, step 2, step 3 under the Restatements Third of Torts, Section 7, 37, 38 through 44. We're adopting that. No longer are we going to use the categories of trespasser, licensee, and invitee. Here's the caveat. Please hear me. While Rowland is very important, because I've listed some of the states, this is not an exhaustive list. I listed some of the states that adopt the same stance as California, that have rejected the strict categories of trespasser, invitee, and lessee, right? Rowland is not the restatement. We've got a lot of students from California, or a lot of students who plan to either return to California or go to California, thought this was important enough to include in the review, but understand that we still have a nice representation of states who have not adopted Rowland. I'll call those no Rowland states, right? That's Texas, Florida, Georgia, North Carolina, Virginia, Alabama, Mississippi, not exhaustive. So what do the non-Rowland states do? The non-Rowland states do not rely on 737, 38 through 44. They rely on an actual restatement, and that's Restatement 51. Okay, that's all I want to say about premise liability now, because we will get to premise liability, but we will get to premise liability a little bit further down the road. Yeah? Excellent. I'm going to stop right there. This slide just has additional cases where we've gone through step 1, step 2, step 3, step 1. It is Restatement Third of Torts 7. Step 2, Restatement Third of Torts 37. Step 3, Restatement Third of Torts 38 through 44. But hopefully this helps put the bookend on the end of modern duty analysis under the Restatement Third of Torts. It's been fun. I look forward to seeing you on video 3.